Hello there, everybody. Welcome back to Legal Talk. I'm the host of your show, John Mitchell. I was out last week, in Big D, Dallas, Texas, at a big tax convention. And so that was very exciting times. And I am so happy, pleased to be back with everybody on the show today. And we've got, a treat for you, as always, couple of treats, actually, so there you go. It's very interesting. I was reminded the other day because we all have difficulties in life. We all have things that we go through. And sometimes, the secret to life is perseverance, right? And I thought about, back in the day, a long time ago, many moons ago, when Alexander Graham Bell was trying to invent electricity, so to speak, right? And had to fly that kite with the key on it, and the lightning struck and all of that. I mean, lightning did not strike the very first time. He had to persevere. He had to fly that kite many times before he finally discovered electricity. And so that was a very big lesson to all of us. There's many examples of that. Wright brothers, Colonel Sanders, man, he tried, in the electric light bulb. Anyway, there's many examples of that. And I'm, dealing with some stuff right now, that you just got to uh, you got to have some perseverance and stick to itiveness, and you'll get through to the other side. And so that is kind of like the overarching life lesson for today, right? This is what I've been thinking about today, and of course thinking about also some good legal topics and some good tax topics in particular. And these two questions came in to my inbox actually very recently over the past week or so, week maybe 10 days, And as I always promise, now put a sticky note on this and think about it. All right, if in fact you folks out there are watching the show and you want to ask a question, tax question, legal question, whatever it may be, feel free to go ahead and shoot me an email to my email, jmitchell@cctaxlaw.com. And I will try to make sure that I either answer your email, give you a quick phone call, or perhaps maybe if it's a question that can be answered here in the big show, we can answer it on the air, and that way everybody can get the benefit of that answer, right? So I love to do that that way, and I love to get questions from people. So one of the questions I just got, like I said, within the last week or 10 days or so, is about money that is received from an inheritance. And so that's basically, now we're using the word inheritance not in its technical sense, right? Because an inheritance is more specifically referred to somebody died without a will. Okay, so Grandma Millie passes away, never took the time, never made the effort to write a will, and now she's passed away, and so now the law, the judge has to decide who gets what out of Grandma Millie's remaining estate, right? So that's when you say the word inheritance, that's the real technical term is money that you would get through what they call intestate succession. Intestate succession meaning people have passed away, they didn't have a will, right? So what I'll do is I'll quote, and believe you me, this is short. I'm not going to take a long time with this. In fact, I have my little notes here so that I don't miss any words or get this wrong, right? So question being is money that somebody passes away, you get money. Is that money includable in your payment, your taxable income, right? Do you have to pay taxes on that? So I'm going to point you to Internal Revenue Code Section 102, and it says just like this. It says gross income does not include, and when they say gross income, they mean for taxes. So gross income does not include the value of property acquired by gift, bequest, devise, or inheritance. And some people have asked me, John, you lawyers, you like to throw a lot of extra words in there. You guys charging by the word or what, right? And so let me just break that down real quickly in case you wonder. Okay, so property acquired by gift. Okay, that is, let's say my parents really like me a lot and they decide call me up, today, later on today, and they say, John, Hint, hint, in case you're watching the show, right? So, John, I really, really like you're a favorite son. Here's a nice check for $10,000. It's a gift for you, just because we love you, right? Now, that is a gift that is received, and we call it in the legal terms, we call that inter vivos. So it's just a fancy word meaning when somebody's alive, right? So inter vivos, that's an inter vivos gift. So money received by gift. Code section 102, that is not taxable, right? So you can give me much money as you want as a gift, and I don't pay taxes on that because it was given to me as a gift. All right. So that's gift. Now, the next word in the sentence here is bequest. And so bequest and devise, that is when there is a will, okay, and somebody passes away with a will. Now, a bequest means that they have left you some piece of personal property, not real estate, not real property. So let's say Grandma Millie passes away and she writes a will and she says, okay, you're my favorite nephew, you get the family heirloom diamond ring, right? Well, diamond ring is not real property. It's not real estate. So that the correct term for that, the correct way to say that is it's a bequest or I bequeath to you, right? So that's a bequest. And then there is devise. And devise means that you got property through a will, and that is specifically referring to real estate. So that's real property right there. Okay. So that's the difference between bequeath, bequest, and devise. And then finally, you got inheritance, and we already talked about that. That is when somebody passed away that you because they passed away, you get something, and the inheritance passed to you through operation of law, not through a will, right? So that's the technical term. I hope everybody has not fallen asleep by yet, but that's the way those words come together, right? That's why we lawyers use so many words, because each word kind of means a little bit different thing, right? So now that we got all that out of the way, somebody passes away and they leave you a big box of cash, right? And believe you me, that has happened, right? So somebody passes away, you get a big stack of cash. That is not going to be required to be included in your taxable income, so you do not have to pay taxes on that. Now, here's where a wrinkle comes about, right? Because let's say instead of a big stack of cash, they leave you a bank account. You got a CD or something, right? So somebody leaves you a bank account. That bank account is drawing interest, right? Hopefully, we fingers crossed, we hope you're getting interest from that, right? So if you're getting interest from that, the amount of money that the person left you is not taxable, but from the day that they pass away and that money becomes yours, and it's in the bank and it's drawing interest, that interest is going to be taxable. You have to include that in your income. You got to pay taxes on that, right? Okay, so let's say instead of a bank account, let's say they left you some stocks, right? So stocks sometimes pay dividends. And so those dividends are going to be taxable income to you. A lot of times you'll say it'll be like an 8% annual dividend paid quarterly. So $100,000 worth of stock might pay you $2,000 every quarter, right? Just to show some numbers, right? Don't all you stockbrokers out there, try and shoot the messenger. It's just for example purposes, right? So let's say you got some stocks. The stock itself that you received is not taxable income, right? But any dividends post mortem, right? So Grandma Millie passes away, leaves you the big stock pile of stock instead of a pile of cash. Now that stock is getting dividends, and those dividends are now taxable income for you, right? Now, let's go along with another example. Let's say Grandma Millie did pass away and she left you a big stack of stocks, right? So what happens to those stocks? Let's say you decide, the market's up, I rather have the money, need cash, whatever. I got a lot of bills, let's sell that stock, right? So you get when somebody passes away, when somebody dies and leaves you something, let's say stock in this case, you get what's called a step up in basis. Now imagine like a stair steps, right? So whenever you like, let's say you bought stock and then you're going to sell it. You held on to it 10 years and the stock's double or triple what it is the value when you bought it, right? So you bought that stock for $1,000 and now it's worth $5,000. Let's just say, right? So if that's the case, then you're not going to pay taxes on the whole 5,000 that you sold it for. You're going to get to deduct whatever you bought it for, right? So you sold stock for 5,000, you bought it for 1, that's a gain or a profit of 4, so you're going to pay tax on those 4. Here's something fun, right? And wealthy people do this all the time. So that's why we love wealthy people, right? So what the wealthy will do is leave stock for their future generations, and that stock gets what's called a step up in basis. Again, remember, like I said, imagine like stair steps, right? So what you can do is you can let's say Grandma Millie purchased that stock, back on her 21st birthday, and then she held on to it for all these years and passed away. Now that stock is yours. Well, she may be bought, you're going to sell that stock for $10,000. Maybe she bought it for $100, right? But you don't have to take $100 as the basis, because when she passed away, the stock was worth 9,900. It's gone up an extra $100 in those intervening months. And now, guess what you get to do? You get to sell that stock for $10,000, and you get to take a basis deduction of 9,900, because that's what the stock was worth on her date of death, right? And now you're going to pay taxes on the little bitty $100 gain that you got holding on to that stock for a few months after Grandma Millie passed away. So that's a what is known as a step up in basis, and that works not only for stocks, that works for real estate, that works for really anything. So that is a very important thing to keep in mind. Just a couple extra things to keep in mind. If somebody leaves you a retirement account, 401k, an IRA, those have special rules because you would take required minimum distributions. I'm not going to get into all of that because that's a big, thick book full of rules. But you got to take distributions. You got to take money out of the IRA or 401k, and that is likely to be taxable income because why? You're stepping into that person's shoes. So Grandma Millie saved up a bunch of money in her IRA, gave the IRA to you. Those monies that you withdraw from the IRA are likely, if it's a traditional IRA, it's going to be taxable. Reason why? Because she took that as a deduction back in the day when she made the deposit to the IRA. So now it's going to be taxable income. It would have been taxable to her when she drew it out. And so now you're drawing it out. So now it's taxable to you, right? And one final thing that I'll say about taxability of inheritances and inheritance, again, I'm using the term in general terms. Somebody passed away and you get some property, right? So that's what I'm talking about here. I'm not talking the technical term inheritance, but there might be estate tax due and there might be state taxes. Estate starting with an E and state starting with S. So I'm here in the great state of Texas, so we don't worry too much about state taxes, So other parts of the country, your mileage may vary, but that's why you get a competent tax person in your jurisdiction. So that is wonderful. And I am so happy that everybody stuck with us. Hope you didn't hit that snooze button and fall asleep or anything. But that's the way it works. If you get money from, somebody passed away and you get money, that's the kind of the basic rundown of the tax situation. So again, my name is John Mitchell, host of the show. My email address is jmitchell@cctaxlaw.com. And my telephone number is 713-333-0555. If you've got problems with the IRS or need to ask tax questions, whatever the case may be, feel free to reach out. I love to talk to people. I love to help out with tax situations. And that is the way that you can get in touch with me. Now, I am going to go real quickly to a nice little commercial break. We gotta say hello to our sponsors. We gotta pay a few bills, and I will be back with more legal talk right after these commercial breaks. So do not go anywhere. That's my best advice for you today. So be right back. All right, everybody. Well, welcome back to Legal Talk. Man, I'm sure I'm excited, happy today to have everybody out there in the audience with us. I'm so happy that you stuck around through that wonderful commercial break. I really hope that you were able to get the warm or cold beverage of your choice, and you're able to, get comfortable and settle in, because I got another thing to talk about for you today. Now, this is another question, like I said before. If you got tax questions you want to, ask me, you can email me. My email, by the way, jmitchell@cctaxlaw.com. And you can email me your questions, and I'll either do one of three things. I'll either call you up and we'll chat a little bit on the phone about it, or I might send you an email. Or if it's a question that I think is a good fit for the show, I will absolutely make a segment out of it, just like I did this, because I got this question just about, I'm going to say 3 or 4 days ago as I record this. So this is hot off the presses, right? You see, I've got it written down here. The paper's hot, right? It's hot off the press. So I got this right here, and I'm going to answer the question live on the show for that person that kindly sent me this question, right? So the question goes like this. I am a minister. So welcome, minister. Thanks for watching us. So I'm a minister. I get a salary and a housing allowance. Is the housing allowance considered income, and how is it reported? Right. So that's going to be an interesting. Now, I had not known this a long time ago, and I don't do a lot of minister tax returns. I don't do a lot of tax returns at all, actually, but I do know, the basics of it. And the basics of it is this. A lot of times, a minister, a pastor, a reverend, a priest, whatever you want to call it, right? Clergy. That's the nice, inclusive, terminology that we use for all of this, right? So if you're a member of the clergy and you've got a congregation, you got yourself a church, a little church, or maybe a big church, and they are paying you. It's very common amongst the clergy to get paid a salary, and then that salary also, apart from your regular salary, you'll get some kind of a stipend, some kind of a housing allowance, right? That can take the different forms, right? That can either be a house that the church owns, and they're allowing you to stay there, or that can be rent. So you rent a place and they pay for it. So it can be either one of those. But you can get that housing allowance apart from your salary. And the way that's handled is that actually people think of taxes, they think of one big number, but actually taxes can be broken down into different kinds of taxes. So you got your federal income tax on one hand, and then on the other hand, you got your Social Security and Medicare, what they call FICA, right? So that's all together, that's Social Security and Medicaid, Medicare, that's called FICA. So the way housing allowance works, let's say you live in a house and the church pays for that, and the church pays, let's say, $2,000 a month. So they give you, let's say, $3,000 a month as a salary, and they pay an extra 2,000 for your housing, right? So they pay for your housing. So the way that works is when you're a pastor and you get a W-2 at the end of the year, those numbers are going to be separated. It's going to be broken down, because box one of the W-2 is going to be what you pay federal income tax on, and that's just your salary. Then apart from that, it's going to be whatever was spent on housing. So $2,000 a month times 12 months, 24,000. You do not pay federal income tax on that. Okay, but you do have to pay Social Security and Medicare. So that's the FICA tax, and that's going to be 6.42, I think it is, if my Mathematics are not failing me right now, but it's lower six, between 6.5%, right? And so that you're going to have to pay taxes on Social Security. All right. So that's the way that works when you're a minister and you got housing. So we talked a little bit about the churches renting you a place and paying your rent, whatever that can be. Now, what if you just get a lump sum of money, $5,000 a month, and you have to pay rent out of that? Well, you can go back and do that on your tax return. So you're going to have to break that out and call it housing allowance and make adjustments on the return. That can be, and also if the church owns a house that they just allow you to live in, you're supposed to claim the fair market value. So, what would the fair value of that rent be if you were renting a house, right? So, got to calculate that, and then you got to say, well, that's not subject to income tax, but it is subject to Social Security. So, your tax person, whoever that may be, is going to have to figure that out. But long story short, if you're in the clergy, then your housing allowance or money that you spent on housing, sometimes they call it the parsonage allowance, whatever it is, whatever it costs you to keep that roof over your head, right? That is going to be not subject to federal income tax. Now, there's some caveats to that, and again, I kind of know these, but I have my notes here just so that we don't run afoul and miss anything. So the amount cannot be an amount that's more than is reasonable, right? So let's say you're in a kind of a upscale church, right? And you get compensated $100,000 a year, right? Let's say you cannot say that 90,000 of that is housing allowance and 10,000 is your salary because it's got to be reasonable. If you get audited by the IRS, they're going to, shall we say, call you out on that, right? That's not going to fly because it's got to be a reasonable amount. Usually, a reasonable amount is, 20%, 25, maybe as much as 30%. It depends. Facts and circumstances depend, right? But so the amount that you are claiming as a housing allowance and not paying federal taxes on it, you got to divide it up in a way that's reasonable. It's got to make sense. It's got to be fair, right? You can't say I've got this 2, 3 bedroom home in most parts of the country. You can't say I got this 3 bedroom home. I make $10,000 a month. Oh, by the way, 9,000 of that is housing expense. You can't do that, right? So that's one thing. So it can't be more than reasonable. And also, whatever you receive has got to be also spent within that year. So you can't have the church give you a W-2 and put X amount housing allowance, and you can't just build that up in the bank and hang on to it. You got to show if you're audited that whatever amount we're calling housing allowance, that's the amount that you actually spent. It's going to match up, right? My rent is 2,000 a month. The church gave me 2,000 a month. 2,000 minus 2,000, 0. And so you have spent all of your money every month. All of the housing allowance money was actually spent on housing. And it doesn't have to be rent, by the way. It could be, there's other things. It could be some, I forget, like HOA fees are probably in there. I know utilities can be in there. So you got a little bit of wiggle room, but whatever you are getting, it's got to be reasonable and it's got to be spent in that year that it was received. And the amount has to be designated in advance. And a lot of times I've seen churches and pastors get caught up on this. So there should be, let's say, in November or December of the year, a board meeting or whatever, whoever's the governing body of the church need to get together, maybe the whole congregation, they get together and they say, we're going to allow X amount housing expense for the pastor, right? And that should really be documented in board meetings or whatever. So meeting minutes, and so it should be designated, and that's about it. I already talked about. That's the last point I have here on the paper. If it's in kind, you can deduct the fair rental value. So that's the way that works. If there are pastors out there and you're wondering what to do, maybe you're brand new and you wonder, oh, can I deduct this? Is it taxable? Is it not taxable? What's going on with that? That is the skinny, right? That's the very bare bones about how ministers, pastors, whatever, clergy, how they pay their taxes. Housing allowance is generally free from federal income tax. So that question came in about 3 or 4 days ago, and I appreciate it. Thank you for the minister that's out there watching our show. As I'm sure, I hope you're not the only one, but thanks for sending that question in. And again, this is Legal Talk. My name is John Mitchell, host of the show, and we are happy to have you with us. Please stick around because we're going to go for some more commercials, and then we will be right back after that. So stick with us. Well, hello there, everybody. Man, and welcome back from that big commercial break. I hope you were able to stretch your legs, get the cold or warm beverage of your choice, and you are settled in. Got yourself strapped in, seats in the upright position, and the tray tables are up and locked in, and we are good to go for another segment here on Legal Talks. I got some good information for you. Now, this is an old classic, right? This is a thing that has been asked of me, I mean, probably a bit 100 times, right? And that's just in the past year. So this always comes up, right? Now, we all have heard commercials on the TV and on the radio, on cable, whatever. Hey, do you owe money to the IRS? How about paying pennies on the dollar? We can settle you for pennies on the dollar. You owe 100,000, you're going to pay 2,000. Now that actually, I'm here to tell you that does exist. Okay, and I myself have been able to get some really good good results. I mean, probably one of the bigger ones that I can remember in the past couple of years, we settled about $1.2 million worth of taxes for like I don't know, like $20,000 or something. So yeah, pennies on the dollar, that can work, right? That can be a thing. But here's the thing, right? When you talk about pennies on the dollar, you're usually talking about what the IRS calls an offer in compromise. All right. So an OIC, we call it in the business, right? So offer in compromise, and that is actually, I wrote this down. That is a section 7122, actually, of the Internal Revenue Code, 7122. That is the section of the law, because remember, IRS doesn't get to just do whatever they want. They don't just do what they feel like. IRS folks cannot just wake up today and say, "Oh, I think old Bob seems like a good guy. I think I'll write his taxes down a little bit because he's, struggling, whatever. I think I'll do that." And there's nothing behind it, right? So there's got to be whatever the IRS or really any government office, any government official, or any government agency wants to do, there's got to be what we call legal authority, right? So legal authority is some section of the law. Congress passed it, the president signed it, and now it's in law. And then this federal agency can do X, Y, and Z thing because it's in the law, right? So offer and compromise is in the law and has been for, I don't even know how long, but a long time. It's not a brand new thing, despite what the radio commercials would like to tell you, right? So, so offer and compromise means that means that you are going to pay less than you actually owe. So let's say you get out your big calculator and you crunch some numbers and you do your taxes and you figure out, or your tax guy figures out, or the case may be, right? So you figure out, well, I owe the IRS, $100,000. All right. May you be so lucky, because if you owe 100,000, that means you made a lot more than 100,000. So good for you, right? So let's say you get your big calculator out and you figure out, well, I owe the IRS $100,000. Oh my God, guess what? My pet goat died. I had unexpected funeral expenses, whatever happened. Oh my God, I don't have money. I can't pay the $100,000, right? or as the case may be, as we'll see, right? For XYZ reason, whatever it may be, I want to settle with the IRS. Now, people sometimes think, and this is not the case, right? They think they're down at Uncle Sammy's used car lot and they look at, they look at a real cream puff of a car. Watch how they spit in their hand and say, okay, a deal for you. I'll give you X amount, right? But that's not the way that works. IRS can make a deal with you. And so we already talked about the section of the law that allows you to allows IRS to compromise or to make a settlement with you, right? There's basically three kinds of settlements, okay? There is doubt as to liability. And basically, I'm not going to get real technical. Doubt as to liability means, yeah, IRS, you say I owe that amount of money. I'm not so sure. I don't think that's correct. I think, instead of 100,000 that you say I owe, I think I really owe 20,000. So here I hereby offer you 20,000. Right. So you're offering the IRS, you're offering to pay them the amount that you think is really due, not what they have been claiming is due. All right. So that is doubt as to liability, and that is one way to make an offer to the IRS. And if you can convince them, if you can show that that's actually, your numbers are accurate, then yeah, they'll go ahead and make that deal and say, okay, 100,000, our bad, we'll take 20, and there you go, right? That's one way you can go about it. The other way to go about it is what is called doubt as to collectability. Now, whereas doubt as to liability means, hey, I'm claiming I don't really owe that money that you say I owed, and therefore I offer you less. Doubt as to collectability is, yeah, I owe the money, or most likely I owe the money. But guess what? I'm broke. I can't afford to pay you, right? So it's in lieu of some kind of a maybe the other way you might have gone with that is bankruptcy, right? So to think of this as like a miniature bankruptcy, but only with the IRS, right? So I owe the IRS 100,000. I'm not disagreeing that I owe the money. I just can't afford to pay because I'm broke. Well, what can you, then it comes RCP, they calculate reasonable collection potential. What can you afford to pay? So you're going to have to give the IRS a bunch of information, bank statements, pay stubs, et cetera, et cetera. Mortgage of your house, mortgage statement, all this other good stuff, right? It's a big, thick list of stuff they're going to want. Long story short, they want you to demonstrate that you can't really afford to pay. And if you can show that, if you can demonstrate that you cannot afford to pay, I owe 100,000, all I can afford to pay is 3,000, then they will go ahead and take that 3,000. So that pennies on the dollar thing that does exist. Now, there's one more kind or type of offer and compromise that I could mention, right? So we talked about doubt as to liability. I don't really owe the money. We talked about doubt as to collectability. Yes, I owe the money, but I can't afford to pay. Now here's the last one, and it's kind of weird. It's not very often used, effective tax administration. And so effective tax administration is, yeah, I most likely, almost certainly owe the money. Yes, I owe it. And yeah, I could probably pay it. Maybe if I sold my home and lived in the street, I'd be homeless. So there you go. Maybe I could afford potentially to pay it, but it's really not fair. It's not going to look good, publicity wise. It's not going to look good for the IRS to be, charging me this money. So that is what we call effective tax administration. And real quickly, one way that I used effective tax administration was there was a company, the owner was very elderly, there were some penalties. She passed away for cancer. I used an effective tax administration argument and got the IRS to abate or wipe out a bunch of penalties based on the argument that, look, the lady that screwed up and didn't do this right in the first place is already dead, and the company can't afford to pay, couple of $1 million in penalties are going to go out of business. And so all these people are going to lose their jobs. And by the way, it was a home health company. So all the people that are patients that count on that company are now going to lose their health care because, you IRS shut them down by charging these gigantic penalties, right? So they backed off and did not charge the penalty. They abated it. So that is what we would call an effective tax administration, argument. Yes, I owe the money. Probably I can afford to pay, but guess what? It's going to bankrupt me. It's going to put me homeless, whatever. And so they will just, write it off based on that it's not equitable or it's not fair for you to be paying that much of a penalty, fee, tax, whatever it may be. All right. So that's the three kind of offers in compromise. And there's very strict guidelines and you've got to qualify for those in order for the IRS to be able to accept them and write off some of your tax debt. So yes, that does exist, but there's a whole lot of caveat behind that, right? So thanks for the question. It's a classic question. I get it all the time. And thank you, everybody out in the audience, for being with us. We are going to go to one more quick commercial break, and then we will be back with more legal talk. So please stay with us. Don't go anywhere. We got more good stuff to come. All right, everybody. Welcome back to Legal Talk. Again, I'm your host, John Mitchell. I know you already know that. You've been watching the show. You're going to watch till the very end because this is the last segment. So I know you're already here. You're strapped in. You're ready to go. You got your, commercial break. You had a chance to get up. You stretch your legs. You got some hot or cold beverage of your choice, whatever that choice may be, right? Could be adult beverages or regular beverages. Hey, we don't judge around here, just as long as you keep your eyeballs right there on the screen, keep watching the big show for us, right? And I have got more good content for you, so hope you're comfortable and ready for some more good information. Now, as we have been promising, and I've been saying this for a few weeks now, and mea culpa, I didn't get to it yet until now, but finally we're here, and there is no turning back, man. There's no retreat, no surrender, and we are now expanding the Legal Talk show. I'm a tax attorney, specialize in taxes. I know things about taxes that you just don't even want to know, right? But I didn't go to only tax law school. I went to regular law school, so we can talk about some other legal issues as well. And so one of the things that I have been talking about lately is that 'tis the season. So and by 'tis the season, I mean the season when the Supreme Court comes out with new rulings, right? They've decided some important cases. This is a blockbuster, and if you're not, if you're not in on this, I mean, I know everybody doesn't live in my world, but this is going to be huge, right? So for about 40 years now, the rule of law has said basically there's a thing called Chevron deference, right? So Chevron deference means that basically what it is, if there's a federal law, okay, and that law has any ambiguity in it. Ambiguity meaning you're not sure which way the thing's going to go, right? What does this really mean, right? It's ambiguous. So if the law has any ambiguity in it, then if there is a conflict that arises out of that, a legal conflict, then the way that courts are going to go about deciding that conflict is, first of all, if there's a federal agency on the other side of the conflict, the court would give deference, and they call it Chevron deference. I'll tell you why. But they gave deference to whatever the federal agency said was their reasonable interpretation of the law, right? So in order for the courts to come along and say that a federal agency is wrong about how they're applying the law, there was a bright line test. It has to exceed reasonableness. It has to be unreasonable on its face, right? No reasonable person could decide that it was like that. This has been the case for 40 years now. So for 40 years, back since the 1980s, it's been the case. Chevron deference has been the way it is, right? So it's a principle of law that the court will defer to the government agency. I'll tell you how this got started. This got started because back in the 80s, there was this court case, Chevron versus National Resource Defense Council, right? Don't worry, I'm not going to get into technical stuff, but basically there was an EPA regulation, and the EPA, the argument at the time was whether, let's say you got a refinery, right? Is that refinery one big source of pollution, or is each smokestack in that refinery its own separate, source of pollution, right? That was kind of the really, really basic argument, right? So EPA had made a ruling and said, the plant is one big source of pollution. And so basically, if the owner of the refinery wants to make changes, they don't have to go through a bunch of complicated re-permitting. Think about what was going on. 1980s, that's Ronald Reagan. That was the era of deregulation. Remember Reagan said this, government's not the solution to your problem, government is the problem, right? So the winds of the time were blowing in a direction that we want things to be less regulated by the government. And so the EPA, along those lines came out with this rule. Okay, so you got yourself a refinery, let's say, or a chemical plant, whatever. So each smokestack is not its own source of pollution. The entire plant's a source of pollution. So you can make changes where maybe one smokestack emits more pollution, but the other one is less. And they can go ahead and say, okay, we're going to even that out and call it all even, and it's good. You don't need to go through a bunch of extra processes to get air quality permits and stuff. And so that's the way that, that would work, right? And so now, after 40 years, the court has determined that Chevron deference is not in order anymore. So there's a couple of cases that the court was looking at, right? So one of them was called the Relentless case. And if you want to get out there and fire up Google and, double check me on all of this, you can do that. So I'm going to give you the citation. It's case number 22-1219. So go to Google, type in Supreme Court 22-1219. Boom, it's going to take you there. And be sure that you have a big, giant cup of coffee, because it's going to be, your insomnia might take over. And the other case that they decided was called Loper Bright Enterprises, and that was case number 22-451. And basically what the courts have now, what the Supreme Court has now ruled, is that agencies, so government agencies, don't have a special competency in reviewing statutory language, and the courts do. So now we're not focusing on the technical things, we're focusing on the law and what the statutory language should be. And the Supreme Court has said, well, that's the purview of the federal courts, and so that's the way we're going to now do it. So Chevron deference, boom, out the window, right? And so what they've said was, the Roberts, Chief Justice, said that courts must now use independent judgment to determine the meaning of ambiguous federal statutes. So that's going to be, that opens up way, like a lot of big can of worms, right? Just in my practice, I deal with federal taxes. There are Treasury regulations, and believe you me, the Congress will write a law, right? Congress is, let's say it like this, they're the big idea people, right? So a congressman will get with his other congressman friends and say something like, well, hey, you know what would be cool? Let's not have bad stuff in our drinking water. You like to have clean water to drink? I like clean water. You want to drink dirty water? No dirty water. Let's drink clean water. Okay, so big idea. Let's not have bad stuff in the water, right? These congressmen, they're not scientists. They're not environmental scientists. They don't know necessarily, what percentage of contaminants might be good or bad or whatever, right? Good, bad, or otherwise. And so what they do is Congress will write the law in such a way that the statutory language will say the secretary shall or the administrative agency shall provide regulations that do this, that, and the other, right? X, Y, Z. So Congress will set the goal and say, what's our goal? We want clean water, okay? Now, you administrative agency, EPA in this case, go out and figure out how to make that happen, right? So they intentionally write the law in this way so that the language is ambiguous, so that the agencies can go in and fill in the blanks and kind of get the details taken care of, right? And so Chevron deference now, it's if you listen to people on one side of the aisle, they'll tell you this is really going to be open season now, because now everybody is going to be out there filing lawsuits against the agencies, and the courts are no longer bound by stare decisis, right? Breaking out that Latin again. They are not bound by Chevron deference, right? And so all this does is open up a little bit more leeway, and it puts decisions more in the hands of the courts and less in the hands of administrative agencies. Very important to my day-to-day practice, because IRS and United States Treasury Department, they issue buku regulations about how the law should be interpreted. So, I anticipate there's going to be a lot more litigation out there, and it's going to be a developing area of the law. And when other things develop, I will be here to tell you all about it, because that's what we do here on Legal Talk. We provide you with really good, solid legal information, right? So again, my name is John Mitchell, host of the show. I can be reached at 713-333-0555. Or you can shoot me an email, jmitchell@cctaxlaw.com. If you have legal questions, if you have an IRS controversy, please reach out. I'll take good care of you, right? If not, if you have just any general legal questions, feel free to send them to me. If they're interested, we'll get them on the air and make a segment out of them. So again, John Mitchell, host of your show. Happy to have everybody with us today. Thanks for joining us, and we will end the show with that, and see you next time on Legal Talk.
This has been a Now Media Networks feature presentation. All rights reserved.